Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was accused of vandalism. Criminal attorney, criminal attorneys, DUI attorney, DUI attorneys, criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers. Let's see here. My son is being accused of vandalism. When arresting him, his Miranda rights were not read to him. Well, first of all, let's get into the vandalism aspect. Vandalism is something that can be charged as a felony, or it can be charged as a misdemeanor. Generally speaking, if the damages caused are less than $950, it will be charged as a misdemeanor. Under Penal Code Section 594, that carries up to 1 year county jail. Up to. Now, if it's $950 or more in damages, now we are talking about a felony vandalism under the same code, Penal Code Section 594 here in the state of California. That carries up to 3 years state prison. Now, here's the deal. It says right here that your son did not, when arresting him, his Miranda rights were not read to him. Okay, on TV, television shows, Netflix, YouTube, whatever it is, for dramatic purposes, they cuff you and they say you have the right to remain silent. Anything you do or say will be used against you in court. No. First of all, if they detain you, the cops do not have to. First of all, this is just a detention and not an arrest. You do not have the right to be Mirandized. The cops can ask you all the questions in the world. They don't have to read you your rights. After the arrest, if they're going to ask you questions about the case, not your name, date of birth, address, about the actual case, then they do have to Mirandize you. Generally speaking, after an arrest, like right when they cuff you and they put you in, they don't question you. Now, if they put you into an interrogation room after you've been arrested, they've told you you don't have the right to leave. At that point, if they're going to question you about the case, not about your name, about the case, then they do have to Mirandize you, and they usually read, because they don't want you to say later on that you weren't Mirandized. They're going to read you a sheet of paper and have you sign it, acknowledging without guilt that they read you your Miranda rights, and they're going to also record that. In real life, you will not get Mirandized. They will not read you your rights at the moment that they cuff you. Many people come to my office and they say, well, they didn't read me my rights. I'm like, okay, so at what point did they ask you a bunch of questions about the case? Oh, they didn't. Oh, they didn't put you in an interrogation room? No, they didn't. Well, then they don't have to Mirandize you. That's just on TV. That's the truth. They do not have to read you your rights. They do not have to read your rights. The police do not have to read you your rights until after you've been arrested and before they ask you questions about the case. Not your name, birthday, and all that stuff. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comments section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, call us now for a free consultation at 1-800-862-7677. Criminal attorney, criminal attorneys, DUI attorney, DUI attorneys, criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers.